नमस्ते. So now let's prepare an answer for Article 368 के ऊपर कोई सवाल आए यही लिखना है. केशवानंद भारती के ऊपर कोई सवाल आए, you have to write this. In fact, anything that traces out the history of Golaknath, Sajjan Singh, Shankari Prasad to Keshwanand Bharati, you have to mention these pointers, whatever I'm going to just give you. Anything that is talking about Article 13, 368, discuss, decide, or criticize, we will get all the pointers in this lecture. We have already discussed about the interpretation of the Constitution, right? That's where we started from. So it's amendability of the Constitution. So times are not static, times change, and therefore the life, write this down. The life of a nation is not static but dynamic, living, and organic. Its political, social, and economic conditions keep changing. So we are trying to tell the examiner that we know why do we need to amend the Constitution, all right? So Constitution from one era may just be inadequate in another era, all right? So therefore we amend to adopt the Constitution to the changing times. That is why we have Article 368 and under Part 20 of the Constitution to begin with, all right? Tell the examiner, see, any Tom, Dick, and Harry can write, Article 368 में there are three kinds of amendments. In the law optional, we are looking at your mind working like this. That amendment है तो सही, लेकिन क्यों है? Why is the law the way it is? Explain to the examiner. Number अपने आप ऊपर आएंगे. One question can be reframed in so many ways, as we'll discuss in the past year question papers. We have to mention these pointers at the most appropriate times as you feel fit in your answer. Now, how do you amend the Constitution? Mind you, we have discussed about the interpretation pehle. So we have discussed harmonious construction, eclipse. We have discussed everything, basically judicial review, primarily speaking, in the previous lecture. We're looking at how do we amend. So there is the informal method, that is judicial interpretation, जो कि हमने पहले बात करी थी. Constitutional text does not change, but interpretation changes. The classic example of doctrine of eclipse, as we discussed in the previous lecture, the word void in Article 13 and how its definition was changed after हमारा जो बीकाजी वाला जो case law. Now the process is slow rather, not develops from case to case over a period of time. This informal method, it's quite slow. So it develops from case to case. Courts do not take the initiative. भाई अब कोर्ट ऐसे थोड़े ना बताएगा चलो जी आज सुप्रीम कोर्ट takes a ऐसे कि आज मूड कर रहा है, open the bare act of the constitution and let us change the meaning of this word. So we won't be changing the word, we will be changing the meaning of the word. ऐसा तो नहीं होने वाला. So courts do not take the initiative. It is only when the question is posed to them do they tell you what do we need to do about the words that are there or the interpretation that are there. So US में there is no explicit reasonable restriction, but the US Supreme Court said that well we can impose reasonable restrictions. India में तो we made it explicit after the First Amendment. Now for example Article 21 free legal aid, we shifted from DPSP under 21 आपका Husainara Khatun and Khatri versus State of Bihar. Doctrine of eclipse, हमारा बीकाजी वाला case we have already explained quite a lot on these aspects, all right? So and now conventional constitutional usages, that is how does, for example, now in the Bare Act, if you open Bare Act, open Article 72 where the pardoning powers of the president given, it's always a dispute whether it's an executive power or a judicial power. I say it's a judicial function given by an executive power, but that's a debate for another story or another day rather. Conventions and constitutional uses. Now there are a lot of conventions from the UK that are not hard coded in our constitution. So they are just conventions. We just know about them. Like for example, the power of pardon, it has to be exercised on the advice of the Home Minister. Whereas the word cabinet defined in the constitution, it's nowhere defined, but a cabinet does exist. It's an extra constitutional body. Pardon on the advice of the Home Minister, it's not written anywhere in Article 72, right? So that is the way that we use conventions to interpret the constitution. Now Niti Aayog is basically आपका कहाँ पे दिया हुआ है? Where is it given in the constitution? Nowhere, right? Now we look at formal methods. So these are informal methods of interpretation and amendment of the constitution. We're looking at formal methods now. Formal methods में there are two kinds of constitution primarily. There are flexible constitutions, there are rigid constitutions. Now flexible constitutions you can amend by constitutional amendments, you by an ordinary act, by legislative process. Lok Sabha में bill pass किया, Rajya Sabha में bill pass किया, President से send दिलाया, that's flexible. Rigid में there's a constituent process in which amendment requires a special procedure. US में you cannot change the constitution very easily because it's an extremely rigid constitution to a very high degree. Ours is a mixed. All right, always do remember in part 20 article 368 is given, and now let us discuss out article 368. Now, three kinds of amendments that are there. So one's less significance. आपने, for example, you have to basically enact a law under article 2 and 3. So as per article 4 just simple majority से काम चल लीजिएगा. So there's a less significance, ज़्यादा कोई special majority वगैरह की ज़रूरत नहीं. So we have basically our constitution makers, they envisaged each and every possibility. Then there is the procedure. So that's article 368 में you need to pass a special majority, and if you are touching any features that will basically be affecting the center state relations, or any features that will be affecting primarily the state legislatures, you will have to get a ratification done by 1/2 of the state legislature. It's a good time to pause the lecture here and open article 368 and review it once to commit it to memory. So the first में example है about the article 2 and 3 वो मैंने आपको बता ही दिया है. You really don't need a special majority for that. Article 169, if you have to abolish a legislative council, for example, go ahead, do it. But if आपको ये काम करना है यहाँ पर, it's तो under basically आपका नहीं तो दूसरे तरीके का क्या है कि 368 में you require a special majority. If you didn't pause the lecture, well, here is 368. All right, it's primarily been amended twice. All right, but actually third time also it's been amended by the 101st Amendment Act. मैंने primarily बोला है, primarily is basically significant changes. 101st Amendment Act पे हमें छोटी सी एक यहाँ पे 279A लिख गया, but primarily it's been amended twice. All right, now by the 24th Amendment Act, first and foremost, we changed the title. So tell the examiner that you know that we changed the title. Let me zoom it in so that it gets better for you. So by the 24th Amendment, we substituted power of Parliament to amend the constitutional procedure thereof for the words procedure for amendment of the Constitution. All right. Now I'm not going to obviously be reading out the article again and again. We have also discussed this time and again. So just read it. And primarily speaking, we have gone after the amendment procedure by some constitutional amendments. So we are looking at the 24th Amendment. Nothing in Article 13 shall apply to any amendment made under this article. वो कह रहा है जी 13 के अंदर that if you pass a law or if there is a law that violates your fundamental rights, वो कह रहा है जी ऐसा है. Anything that I do under 368, Article 13 cannot stop me. This was declared by the 24th Amendment. And by the 42nd Amendment, it says, no amendment of this Constitution made or purporting to have been made under this article, that is under 368, whether before or after the commencement of Section 55, पूरा पढ़ने की जरूरत नहीं, shall be called in question in any court or any ground. यही जो चक्कर 3-4 वाला जो चक्कर है 4 and 5 primarily, इसी के ऊपर सारा आंसर टिका है. यही हमने एग्जामिनर को एक्सप्लेन करना है कि जी हमें ये पूरी लंबी चौड़ी कहानी, we know it. Okay, so as soon as you touch the entrenched provisions, that is you change anything by an amendment relating to the President, the Supreme Court and High Court, Part 11, or you change or you touch Article 368 itself, you have to get आपका state legislature का काम. Now, the original marginal note, the heading, as I've already explained to you, it was procedure for amendment of the Constitution. Since 1951, questions have been raised about the Constitution's amendability. कि भाई अब क्या करें? As soon as the Constitution came into, you can say as soon as it's commenced, the question started arising. कि अरे इसका क्या करें? अरे उसका क्या करें? Right? So whether fundamental rights are amendable, that was the first question, first primary question posed to the Supreme Court, and our constitutional history is decoded on this very question: is whether fundamental rights are amendable. Can the Parliament amend fundamental rights? This will straight away cover a 15-20 marker in one go. यही इसी lecture में सभी कुछ है. Now, Parliament can take away any fundamental rights via constitutional amendments. वो कह रहे जी fundamental rights को रोको, and यहाँ पे हम कहानी हमारी शुरू हुई from आपके शंकरी प्रसाद सिंह versus यूनियन ऑफ इंडिया के अंदर, ठीक है जी। अच्छा, अब आपका जी आर्टिकल 31 में क्या है, राइट टू प्रॉपर्टी से कहानी शुरू हो रही है। दिस इज आरटीपी, आई तो राइट टू प्राइवेसी नहीं है, इट्स राइट टू प्रॉपर्टी। आर्टिकल 31 से कहानी शुरू हो रही है, द जमींदारी राइट्स बेसिकली। So the first amendment placed a lot of things, basically in the ninth schedule introduced Article 31A, 31B. So in this case law, we are challenging the bypassing of judicial review by the parliament by placing a lot of acts, thanks to which it took away a lot of your आपका, it violated or infringed the right to privacy or right to property rather, sorry, RTP देख के right to privacy याद आता, तो right to property provided to the people under Article 31, which is given under Part 3, which was rather given under Part 3. So they said, so what the Parliament did was it placed the laws in the 9th schedule and said that whatever is placed in the 9th schedule, the Supreme Court cannot look into those acts. Great, मुबारक हो जी, मुबारक हो गई सबको, right? अच्छा, you cannot look into those acts. तो फिर राइट टू प्रॉपर्टी हमें दे क्यों रखा आर्टिकल 31 में? उस जमाने में 1950s में ये बात हो रही थी। So the first amendment did this. So it's a challenge. The case law was challenged to bypass the judicial review. So the primary question came in. Does the word law here in Article 13, law is inconsistent with or in derogation of the fundamental rights? Does this word law contain the word constitutional amendment as used in Article 368? कहानी यहाँ से शुरू हुई थी, ठीक है जी। Now, so this is आपकी कहानी law. Does law include a constitutional amendment? Now, if it is law as per 368 and as per Article 13 as given in 368, then how can it take away my fundamental right? Because Article 13 says law inconsistent with or in derogation of the fundamental rights. The state shall not make any law which takes away or abridges the right conferred by this part. So if this law is equal to a constitutional amendment as given in Article 368, you cannot pass the amendment that you're doing because it's violating rights given to you under Part 3. All right. The contention in this case was that a law cannot take away fundamental rights. So the final decision was कि जी Article 13, वो contention थी petitioner की, but the final decision by the court is Article 13 वाला जो law है, the word law, it does not contain constitutional amendment as given in Article 368. So they can amend and take away your fundamental rights. यही मतलब हो गया ना. So the validity of the 9th schedule was upheld, but the debate started between legislative power and constituent power. Because see, the Supreme Court is not bound by its own decisions, as we have already seen in Bengal Immunity Company vs. State of Bihar. In the last lecture, we already discussed this. So Supreme Court के सिर में खारिश होनी शुरू हो गई. अच्छा, ये मैंने कर तो दिया है, लेकिन सामने वाले की बात थोड़ा थोड़ा दम भी है भाई. Right, as benches keep on changing, अब everyone's observing what is happening in the Supreme Court. They're like, नहीं, ये शायद थोड़े से गलत track पे. It will get revealed. All right. But we are here only, so we go to Sajjan Singh versus Rajasthan. So via 368, Parliament can amend, abridge, nullify a fundamental right. So people were like, why फिर fundamental right दिए क्यों हैं? If you can amend them, you can take them away at any time. Why are you calling them fundamental to begin with? So this debate started popping up. Now we go to Sajjan Singh versus Rajasthan. That's 1964, 13 saal baad. Alright. 17th Amendment was challenged, wherein via the 17th Amendment, a number of statutes were again placed in the 9th schedule, bypassing judicial review. So the contention was that this moving in, it affected Article 226. कि जी ये क्या कर रहे हो आप? If you are placing such statutes under 9th schedule, aren't you affecting the power of the High Court to look into the validity of the laws? Great point. Now, the decision came with a split of 3:2. दो जज अब बुरा मानना शुरू हो गए कि नहीं ये हम क्या कर रहे हैं भाई. देखिए, डाउट आने शुरू हो गए. शंकरी प्रसाद में तो सब क्लियर था. सज्जन सिंह में शायद हम गलत कर रहे हैं. Right. 3:2 में they use doctrine of pith and substance in this case, and they said that it's not taking away 226, displacement of laws in 9th schedule. It is only amending the fundamental rights so as to help with agrarian reform, and it's helping the state legislatures with agrarian reform. That is the need of the hour, and without this we can't proceed ahead with the development of the economy. Now, majority said, same. The majority decision was same as Shankari Prasad. They said ordinary law is different from constitutional law. कि जो आपका कॉन्स्टिट्यूशनल अमेंडमेंट वाली जो है वो पोर्शन वो अलग है फ्रॉम व्हाट इज गिवन एज द वर्ड लॉ इन आर्टिकल 13, राइट. बट ये दो जजेस ने जो काम किया था, इन्होंने ही समझ लीजिए पूरी गंगा खोल दी, यहाँ से बहा दी कि जाओ बेटा तुम जाओ, बाकी तो लोग नहा लेंगे उसके. हिदायतुल्ला जी एंड जस्टिस मुधोलकर, हिदायतुल्ला जी सेड कि भाई साहब मुझे समझ नहीं आ रहा है कि पार्ट 3 में स्टेट इज अश्योरिंग यू दैट यू विल हैव दीज फंडामेंटल राइट्स, करेक्ट. द कॉन्स्टिट्यूएंट मेकर्स आर अश्योरिंग यू एवरीवनस डूइंग द सेम थिंग, एंड हम कह रहे हैं बाय आवर डिसीजंस इन शंकरी प्रसाद एंड सज्जन सिंह, वी आर सेइंग द स्टेट कर रहे नलिफाई करा लो, कोई प्रॉब्लम नहीं. वो कह रही है यार फिर देन हाउ आर वी अश्योरिंग फंडामेंटल राइट्स टू द पीपल. फंडामेंटल शब्द है ही क्यों, right? And in Justice Mudholkar said, well, every constitution has some fundamental features that cannot be changed, buddy. Otherwise, the parliament can amend everything. They can rewrite the entire constitution itself. तो हमारे वो डॉक्टर B.R. अम्बेडकर, जवाहरलाल नेहरू और जो कॉन्स्टिट्यूशन असेंबली के आपके राजेंद्र प्रसाद, सच्चिदानंद सिन्हा, एक्सेट्रा एक्सेट्रा, महात्मा गांधी वॉज नॉट अ पार्ट ऑफ द कॉन्स्टिट्यूशन असेंबली. वो जो बैठे थे, जो 46 से ऑलमोस्ट समझ लीजिए 49-50 तक बैठे थे, वो क्या कर रहे थे, झक मार रहे थे. तो फिर तो पार्लियामेंट अपने आप कुछ भी लिख देती. Why did we involve the Muslim League? Why did we involve the princely states? Why did we form a constituent assembly? I mean, what was happening there? Based on this, the case law of Golaknath came in. Based on this, the dissents that is there, the minority judgment, the Keshwanand Bharti case law popped up. That's why usually, if it is required, mind you, these days dissenting is quite cool, by the way, even though it's not required. Quite a lot of judges do it because they are playing to public gallery. But anyway, so if it is required and if it makes sense, dissents and minority judgments are extremely crucial. So it's somebody else has won the case, but you're opening up more and more opportunities for reforms or in the thought process of law. Now we go to Golaknath versus State of Punjab. This 1967. Again, the 17th Amendment was challenged, and this time 11 judge judgment came. 6:5 हो गया. अब पहले हम 2 को पकड़े थे, अब हम 5 को आ गए. याद है बात. All right. They said, the majority of the judges said fundamental rights are transcendental in nature. This way, if you are basically, our position reverse हो गई है, by the way. 6 अब जीत गए, वो जो 2 थे वो 6 में बन गए हैं और 5 पीछे रह गए हैं. That's how you evolve things, but it's quite a slow process. It's already 67, 1950 से लगे हुए हैं, right? Justice is quite slow. So they said fundamental rights are transcendental in nature. This way, if you are allowing Parliament to do whatever the hell that it wants to with respect to fundamental rights, because that's what we have said in Shankari Prasad and Sajjan Singh, Parliament will over a period of time erode all fundamental rights. It's quite a dangerous position. Then why do we have a part 3? फिर तो हम इनको पार्ट 4 DPSP की तरह ही ट्रीट कर लेते. फंडामेंटल राइट्स, they said, cannot be amended by any constitutional amendment, and the ratio was given that marginal heading of 368 prior to the 24th amendment, it read as procedure for amendment of this constitution, where we began a lecture from. All right. So power of parliament, टाइटल क्या था, मार्जिनल नोट क्या था आर्टिकल का, प्रोसीजर फॉर अमेंडमेंट ऑफ द कॉन्स्टिट्यूशन. वेयर इज इट रिटन पावर ऑफ पार्लियामेंट, तो ये तो कहीं है ही नहीं. 24th अमेंडमेंट इंदिरा गांधी ने कहा, बताती हूँ तुम्हें, रुको मैं पूरा नोट ही बदल दूंगी, उसके इससे आर्टिकल की हेडिंग ही बदल दूंगी. खैर एनीवे, एंड this power of parliament is actually a residuary power as provided for under Article 248. Good time to pause the lecture and refer to Article 248. Hopefully you have your bare acts open. With these comprehensive lectures, you really need your bare acts along with you. Now, therefore, the law under Article 13 contains in itself the law under Article 368. Great. And a constitutional amendment cannot affect Part 13, Article 13, Part 3 rather. Because Article 13 wala law is equal to law passed under Article 368, and Article 13 is saying that you cannot make any law that violates any provisions of this part. Great. So therefore, you cannot amend fundamental rights. अब उस टाइम की सरकार बहुत गुस्सा हो गई इस जजमेंट से. अब वाली जो सारी जो लड़ाई चलेगी, दैट विल लीड अस टू केशवानंद भारती. ठीक है जी. सो शंकरी प्रसाद, सज्जन सिंह, दे वर ओवररूल्ड के चलो चलो तुम साइड हो. Right, but that is why we already discussed on the previous lecture in the course doctrine of prospective overruling, because it would lead to a lot of chaos if you are just annulling all the amendments up till that date. पीछे की सारी जजमेंट, स्टेट लेजिस्लेचर कितनी एक्ट हुई होंगी, कितनी डेवलपमेंट हमने करी होगी बेस्ड ऑन द लॉज दैट यू योरसेल्फ पास्ड इन दीज टू जजमेंट्स, all hell will break loose. So therefore doctrine of prospective overruling की आज से हम prospective आगे की तरफ जजमेंट को अप्लाई करेंगे. ठीक है. Now doctrine of prospective overruling, say we have to save the agrarian revolution, because if the 17th amendment were void now, lead to chaos. And an academic question also arose, that can the parliament really academically, if the parliament is allowed to amend any part of the constitution, well, can it amend the entire constitution itself? So concerns came in, right? So Hidayatullah ji and दूसरे वाले हमारे जज थे, उन्होंने total, they opened the hell gates. Then came in the 24th Amendment. And 1971, the Indian National Congress, they returned with a huge majority. They got in the 24th Amendment, inserted clause 4 to 13 and said nothing in this article shall apply to, अच्छा clause 4 आपका यहाँ पे in article 13 only, nothing in this article shall apply to, बोलते बोलते 368 13 ऊपर हो जाता है, shall apply to 368. मुबारक हो भाई amendment. हो राइट, वो सुखबीर वाला भी गाना भी मुसीबत होनी शुरू हो गई. सो द हेड नोट ऑफ 368 नाउ चेंज्ड. उसने बोला था ना सुप्रीम कोर्ट, पावर ऑफ पार्लियामेंट कहाँ दे रखा है, करे रुको मैं तुम्हें लिख के बताती हूँ, अभी इतनी जल्दी क्या है. लो, पावर ऑफ पार्लियामेंट टू अमेंड द कॉन्स्टिट्यूशन. अब बताओ ओरिजिनल नोट क्या है, प्रोसीजर फॉर अमेंडमेंट ऑफ दिस कॉन्स्टिट्यूशन. ठीक है जी. Okay, and it added clause 3 to 368. Let us look at 3. नीचे दिया होगा 333 here. Nothing in Article 13 shall apply to any amendment made under this article. मुबारक हो. Alright. अब ये तो दिक्कत आनी शुरू हो गई ना, यहाँ पे बहुत बड़ी मुसीबत आनी आपके पास शुरू हो गई. राइट. सो यहाँ पे इन्होंने एक और चीज़ अभी करनी शुरू कर दी कि जी इट शैल बी प्रेजेंटेड, फुटनोट नंबर 8 देखिएगा, इट शैल बी प्रेजेंटेड टू द प्रेसिडेंट हु शैल गिव हिज असेंट टू द बिल. कह रहे प्रेसिडेंट साहब हैज वीटो पावर है ना इनके पास, कभी पॉकेट वीटो कर लेते हैं, कभी सस्पेंसिव वीटो कर लेते हैं, कभी एब्सोल्यूट वीटो कर लेते हैं. टू अ नॉर्मल लॉ पास बाय नॉर्मल लेजिस्लेटिव प्रोसेस, लोकसभा में पास करा जी, राज्यसभा में पास करा, प्रेसिडेंट साहब के पास हमने थप्पा लगवाने के लिए भेजा टू एन ऑर्डिनरी बिल. 24th अमेंडमेंट कहता है जी शैल गिव योर असेंट, इधर आ जाओ, बताओ भाई बताओ भाई. राइट. एंड these are quite tough things that they did. Now 25th, they said 25th amendment, basically they changed the word compensation to amounts, because compensation again courts can decide, amounts the sarkar will decide. All right, so it changed the word. Article 31C brought in, basically आपका ये काम इन्होंने कर दिया कि Article 31C said any law that is enacted for 39 clause B clause C, that is socialist tendencies of the government, it will be exempt from complying with 14, 19 and 31. It is exempt. That is what the 25th amendment said. And in effect, the 25th amendment gave more importance to DPSPs. It actually ruled them to be superior over fundamental rights, because it's saying any law that is being complying, or rather being enacted for implementing Article 39 clause B clause C, it will be exempt from 14, 19 and 31. Mubarak ho. So in effect, DPSP is greater than fundamental rights. Then came in केशवानंद भारती जी. अभी recently गुजर भी गए. केशवानंद भारती जी वर्सेस स्टेट ऑफ केरला की भाई से यार चल क्या रहा है, कौन सा मजाक चल रहा है. Got to the 24th and 25th amendment. Basically this was challenged. Now it was a 13 judge bench and we were reviewing the 11 judge bench का decision from Golaknath as well. Now, power of amendment in Article 368, it was held that power of amendment is in 368 itself. गोलकनाथ was overruled in this aspect कि कोई ज़्यादा कोई लड़ाई करने की ज़रूरत नहीं है. वो जो फुट नोट के ऊपर जो तुम्हारी लड़ाइयाँ चल रही थी पहले कि आर्टिकल 248 के अंदर दे रखी है ऐसी रेजिडुअरी पावर है जी, ये तो ना वो कह रहे जी सब कुछ टू अमेंड इज इन 368 एंड लॉ इन आर्टिकल 13. दिस इज केशवानंद भारती का डिसीजन बता रहा हूँ मैं आपको. It did not include constitutional law, that is constitutional amendment wala Golaknath, therefore in this to this extent was overruled. Thus parliament can amend any part as long as it does not violate the basic structure. ये डॉक्ट्रिन अब आ गई आगे कि ऐसा है. वो जो वर्ड है लॉ इन आर्टिकल 13, it does not contain in itself what is being referred to in 368. You can amend any part as long as you are not touching the basic structure. And they told you like what is basic structure? हम बताते रहेंगे, तुम पूछते रहना, बता देंगे, ऐसा क्या दिक्कत है. थोड़ा सा अभी बता देते हैं इसी केस में, थोड़ा सा आगे बता देंगे, क्या प्रॉब्लम. ठीक है जी. तो थोड़े से फीचर्स ये 3 से 4 आपने अपने आंसर में मेंशन करने ही करने. The supremacy of the constitution is a part of the basic structure, you cannot touch it. Republican and democratic form of the government is a part of the basic structure. The secular character is a part of the basic structure. Separation of powers between legislative, executive and judiciary. Parliament basically ये सारे pointers cannot use Article 368 and just amend the hell out of them. Absolutely nothing doing. And federal character of the constitution. You will not basically be touching it. That 2/3 majority may not represent the minority people of the country, or the 2/3 majority may just not represent what the entire country wants, and there are inherent and implied restrictions of the word amend. Now Golaknath में said कि fundamental rights आप नहीं amend कर सकते. केशवानंद भारती said you can amend all parts, no worries on that. In Golaknath you said fundamental rights are not amendable. Keshwanand Bharti said amend only if the fundamental right is not a part of the basic structure of the constitution. How do you find that? Come to court and ask us, right? हम क्या हैं, वेले बैठे हुए हैं, कुछ पूछो तो नहीं ढंग का. And can parliament rewrite the constitution? No, as many parts fall into the basic structure of the constitution, parliament cannot, right? 24th amendment was held to be valid. 25th amendment, that 31C वाला basically उसके अंदर एक clause था, second आपने अपने आंसर में मेंशन करें ना करें कोई फर्क नहीं है. It held to be invalid. There was 31C में जो second clause था वो valid था. And आपका ये जो है 39 clause B, clause C and वो जो exempt वाला, that Supreme Court, that is absolutely basically the Supreme Court cannot look into this law and it's exempt from 1931. Supreme Court said I can look into it. What utter nonsense is Madam Indira Gandhi trying to do? Now Parliament was now conceded power to amend any part of the constitution subject to the basic fundamental features. आपको कुछ करना है, अच्छा, subject to the basic fundamental, वही मैं सोच रहा हूँ, subject to the basic fundamental features. Basic fundamental features आप नहीं छेड़ेंगे, बाकी आपको जो करना है हमारी बेला से आप करें. ठीक है जी. Now then we go to Indira Gandhi versus Raj Narayan. So in this clause 4 of the 39th amendment was challenged as destroying the part of the basic structure of the constitution, in which it was it was discussed that 39th amendment did this, that it withdrew the election of PM and speaker from the scope of ordinary judicial process, and to void the Uttar Pradesh High Court decision which Indira Gandhi ko the High Court declared the Indira Gandhi election to be invalid. So what they said was कि जी आपने 39th amendment कर दी कि Supreme Court तो cannot look into the election of the PM. कैसे आप मेरा कैसे रिव्यू करोगे? तो Supreme Court या courts cannot look into it. तो मैं तो PM हूँ ही, चाहे उत्तर प्रदेश हाई कोर्ट ने कुछ भी आपकी कोई भी जजमेंट दी हो. तो to exclude the SC's jurisdiction to hear any appeal, the Supreme Court struck it down कि ये बदतमीजी नहीं चलेगी देवी जी यहाँ पर, राइट. तो देवी जी ने कहा अच्छा तुम ये करोगे, और इसके चक्कर में quite a lot of judges, they missed out their chance to be the CJAC. It was like a absolute hellhole back then. What about the 42nd Amendment? 42nd Amendment was again 368. Again, now we are amending 368, and never in the future could a court strike down a constitutional amendment. Brought in Clause 4, no amendment of the Constitution, including provisions of Part 3. So even if we are going to be amending Part 3, they shall not be questioned in any court in any ground. That is what the 42nd Amendment did. And it was challenged by Minerva Mills versus Union of India 1980, right? It reiterated you cannot destroy the basic features of the Constitution. Minerva Mills की कहानी अलग है, but डिसीजन ये था कि भाई साहब ऐसा है आपका clause 4 clause 5 हटाओ पर. Petition was filed. It basically they challenged the taking over a mill under the Sikh textile, it's not Sikh, it is Sikh, SICK, बीमार सरदार जी नहीं, Sikh Textile Undertaking Nationalization Act 1970. और पता चले कोई सिख लिखा है, मैं भी सिखी हूँ बट मतलब सिख नहीं, सिख लिखना है, कभी कभार गलती हो जाती है, राइट? So we were challenging clause 4 clause 5, that was section 55 of the 42nd Amendment Act. So we were basically कहानी ये थी कि we were challenging taking over of a mill under the Sikh Textile Undertaking Nationalization Act. So they said they challenge clause 4 and 5 of 368 because if 4 and 5 are valid, then they cannot challenge the 39th Amendment, right? Which put Nationalization Act, ये आपकी ये वाली जो industry की, thanks to which they took over the mill, and they 39th Amendment put this act in the 9th schedule. So Supreme Court said, well, the power to destroy is not a power to amend. Clause 4, if clause 4 is allowed, then fundamental rights become a mere adornment. Clause 5, well, you can replace, the government can replace the constitution fully. So repeal, because clause 5 reads as repeal the provisions of this constitution, any and all provisions. So Parliament has a limited amending power. That is a basic feature of the constitution. So आपका जो section 55 of the 42nd Amendment was said कि नहीं जी नहीं हटाओ पर इनको, right? ये नहीं होगा. This was held to be invalid. Now, amendment of Article 31C. In Article 31C of the Constitution, for the words brackets, letters, and figures, the principles specified in Clause B, Clause C of Article 39, the words and figures, all or any of the principles laid down in Part 4 shall be substituted. This, as we have discussed, brought in, rather concluded that Part 4 is more powerful than Part 3, that is DPSPs are more powerful than Part 3. The Supreme Court held that fundamental rights are the arc of this constitution. The Indian constitution is founded on the bedrock of the balance between Part 3 and Part 4. You cannot give primacy to one part over the other, as we've discussed in the doctrine of harmonious construction discussion. The minority judgment was given Justice Bhagwati with respect to Article 31C. I don't think that you need to go there for your answers. Now, Vaman Rao versus Union of India, that's 1981 के अंदर क्या हुआ? That they challenged the Maharashtra Agricultural Land Sealing and Holding Act 961. That, again, these acts were being placed in the 9th schedule, so bypassing the judicial review. So all the acts were basically, this move was getting challenged. And this move was getting challenged, and the contention was that you're violating the basic structure by doing this. So it was challenged now that 31A, 31B, 31C, as it stood before the 42nd Amendment, it violated the basic structure. That was the contention. Now, so we are challenging again the First and the Fourth Amendments. So it was held that they strengthened rather than they weakened the Constitution. And जो आपका ये वाला जो scene था कि 9th schedule में you cannot be reviewing laws in 9th schedule. They said till 24th April 1973, blanket protection has been granted, but after Keshavanand Bharati, so this is the date of the judgment of Keshavanand Bharati's date, Parliament inserts a state law into the 9th schedule. It is open to judicial review. So these laws will not receive the protection of 31B ipso facto, that is by that very fact or act itself. Then came in Raghunath Rao versus Union of India. So these are all case laws related to the basic structure in which the Supreme Court enunciated आपका क्या है basic structure में. Unity and integrity of India, though, the phrase is part of the basic structure. Principle of equality as enshrined in Article 14 is a part of the basic structure. Applicability of rule of severability to a constitutional amendment act. 10th शेड्यूल, वेल इट अमेंडेड द 52nd अमेंडमेंट. अब हुआ क्या था जी, 10th शेड्यूल जो 52nd अमेंडमेंट जो आपका जो काम लेकर आई थी 10th शेड्यूल के अंदर, तो उसमें चैलेंज हुआ था. सो इट हैड वन प्रोविजन रिलेटिंग टू डिस्क्वालिफिकेशन ऑफ द स्पीकर एंड एंटी डिफेक्शन पे बेसिकली स्पीकर की डिस्क्वालिफिकेशन का डिसीजन फाइनल था. जस्ट इग्नोर व्हाट आई जस्ट सेड कि स्पीकर की डिस्क्वालिफिकेशन. सो if a member had to be disqualified based on anti-defection, the speaker's decision is final on that disqualification. So they wanted, well, is the doctrine of severability applicable to a constitutional amendment act? Yes, because we struck down one particular paragraph only from that amendment. And that's about it. So इसका ये अब basically इसमें थोड़ी सी confusion है कि इसका नाम भैया का किलहोटा है किलहोटो है, because different documents stated differently. So मैंने फिर भी किलहोटा Holohan versus Zachilu likha hua, that's 1993. So question is, the finality clause has the effect of restricting the power of the Supreme Court and High Court. Therefore, under Article 368 Clause 2, this constitutional amendment ought to have been ratified by the one half of the state legislatures. तो ये जो चीज़ जो आपने करी है, does it affect the power of Supreme Court and High Court? They said no, it did not. And question was, is the whole of the constitutional amendment invalid or the finality clause will be severed? 3:2 में कह दिया गया कि जी only the finality clause will be severed, right? Constitutional amendment cannot be invalid. Basically cannot in the sense it's not invalid on its own. You can just split that part. Now A.K. Roy versus Union in 1982, basically it was the 44th amendment. Section 1 clause 2 said, or subsection 2 said, it shall come into force on such date as the central government may by notification of the official gazette appoint different dates may be appointed for different provisions of this act. So we have basically 44th amendment के अंदर डेट हमने बताई नहीं थी कि कब से आ रही है. तो A.K. Roy versus Union of India was challenged कि भाई साहब ये डेट ऐसे कैसे आप छोड़ दोगे हवा में. तो the Supreme Court said कि जी ये no notification है तो it violates दी आपकी 14 and 21, it violates कि ऐसा कोई arbitrary power of the executive है, right? But by 3:2 these arguments were rejected. The Supreme Court can't compel the government to do what is in its basic discretion to do. So we cannot ask them to law लगाओ तुम अभी के अभी, right? So up till now if you make a summary of, अच्छा कहीं by chance मैंने ये ना बोल दिया, so these were contentions पिछले वाले पेज पे जो 14 and 21 कहीं बोलते ये ना बोल दिया कि नहीं जी नहीं ये तो सुप्रीम कोर्ट का डिसीजन ये था, that the Supreme Court can't compel the government to do what is in its basic discretion to do so. तो in Keshavanand Bharati by Chief Justice Sikri, आपको obviously these are quite a lot of pointers but they are for multiple answers. तो जब भी आप basic structure, amendability, 368 कुछ भी लिखेंगे तो ये हमेशा सीक्री चीफ जस्टिस केशवानंद भारती का नाम लेके supremacy of the constitution, separation of powers between आपका executive, judiciary, legislature, this we have already discussed पहले भी, republican democratic form, secular character of the constitution, federal character, parliamentary system, dignity of आपकी our India, unity and integrity, fundamental rights. Right to property is not a part of the basic structure as was validated by the 44th Amendment. Democracy, federalism and democracy is given in Kehoto Holohan. Bumai ke andar federalism and democracy. Secularism, rule of law is part as given, or rather, therefore, Article 14 is a part of the basic structure. This is given in Indira Gandhi as Raj Narayan. Judicial review is a part of basic structure, again and again held in multiple cases. All right. Now, that's about it, I believe. Yeah. I know you cannot remember all of these details, practically humanly impossible. Write down all the pointers, and then when we are discussing past year questions, we will again and again discuss what all points to write and which answer. So this is the entire constitutional history pretty much for our examination purpose. नहीं तो इतने सारे case law जिसका कोई हिसाब नहीं, we have to pick and choose. Alright जी, now see you आगे discussion जो भी है constitution के वाले section के अंदर करते हैं. Then let's move on further ahead. Alright, take care, bye.